The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Three cases will be submitted this morning. Those cases are State of Iowa versus Dwayne Fisher II. Second case is State of Iowa versus Dayanya Taylor. And the final case is Lenora Caruso versus Apartment Downtown, Inc. Those last two cases are now submitted to the court without argument, and we'll hear the arguments in the Fisher matter. Mr. Mears.
Good morning. I feel like I'm going back to my roots, that it was 38 years ago that I had my first argument to the Iowa Supreme Court, and it was a guilty plea. That even though I was mentioning to Ms. Chambers that in the next 10 years I had several other guilty plea cases, and I think I was paid the same as I was today. But that's something I try to work in whenever I have a chance.
Well, that brings up the main point here, and that is Rule 2.8 has provided for a long time this motion arrested judgment procedure, which has eliminated a lot of the appeals. Why wasn't it sufficient in this case? Well,
I was actually talking to Ms. Chambers beforehand about outdated forms in courthouses, and she was saying, unfortunately, that it's not that uncommon a thing, that the State Public Defender's Office, I might add, in Johnson County, does not use the particular form that was used in this particular case by the Lynn County Advocate. The form was just outdated and completely inadequate for purposes of providing that advisory. There are two things you have to do under that advisory. One, you have to tell about the motion, and two, you have to say something about the cost of not being able to raise it on appeal.
Well, right, and I think that's clear, two prongs. Let's work on the second prong. It did say you will be precluded from attacking either one of the guilty pleas you just entered. You will be precluded from attacking. It seems like the Court of Appeals thought that was good enough. Doesn't that at least imply that you can't appeal?
Well, the form says that this is the way that you can challenge your guilty plea, and that it provides that for some time frame references, but that it says nothing about precluding the right to raise it on appeal.
The word appeal does not appear.
That's
clearly.
Right.
And maybe that's the strength of your argument. On the other hand, you will be precluded from attacking. I mean, is it your argument that that's kind of ambiguous, or that?
But the rest of the advisory makes reference to things that you're doing in front of the district court, and that this is the proceeding that you have in front of the district court if you wish to complain about your guilty plea, and that you got to file a motion.
So your view of it is that someone could think you're precluded from attacking in the district court unless you file a motion to arrest a judgment?
Well, that's the language in the rule. I mean, the rule talks about being advised of the motion, and then secondly, that you will be precluded on appeal from raising claims.
So if they would have carroted the word, in your view, and I'm exploring hypotheticals with you, you know we like to do that, you will be precluded from attacking. If they'd carried it in on appeal.
Oh, I think my argument would be much weaker. Yes.
Now tell us about the first prong and why we don't have the first prong satisfied here.
I'm sorry?
Go to the first prong of what's required in a guilty plea. I think are you attacking the adequacy of the first prong of what's required?
No. I mean, I think that to some extent that the basis of saying that the advisory was not adequate has to do with the failure to provide notice with regard to the preclusion on appeal. And I might add that if you look at the cases that have talked about the adequacy of the advisory, there has never been a case that has said that if you don't say something about appeal, you haven't satisfied the rule. But to some
What
extent...
about Oldham?
I'm sorry,
What about the Oldham case?
was that a Court of Appeals decision?
No, I think that's one of ours.
That,
Written application said, I understand if I wish to attack the validity of the procedures involved in the taking of my guilty plea, I must do so by a motion and arrest of judgment filed with the court. Understand the motion must be filed at least 5 days before sentencing and also within 45 days of the date my plea of guilty is accepted by the court. I'm not sure there was a reference to appeal there.
right, and I don't see that materially different than what was done in this case. But answering that part of the question is only a baby step in terms of trying to resolve this case. Because either he can challenge, if there was not an adequate advisory about the motion, then he can challenge the guilty plea directly on appeal. If there was an adequate advisory, which means that he's precluded on direct appeal from challenging the guilty plea, you get back to ineffective counsel.
But on ineffective counsel, there might be a question of prejudice, namely, although he wasn't advised of, in the guilty plea at least, of the driver's license implications and some of the fees and so forth. Conceivably, his counsel told him about that prior, and that might bump you into PCR.
And I absolutely agree that that's why it is fairly important to have it be an inadequate advisory. That is, that the showing that you have to make, aside from which, collateral stuff, that the showing you have to make after, I guess it's the straw case, suggests that it can be difficult on direct appeal to challenge a guilty plea based on ineffective assistance in terms of unless you have something dramatic in the record, which I don't think we have here.
Does this case line up with State v. Taylor, where we found it substantially complied when the defendant was told that otherwise his ability to question the legality of his plea of guilty was gone? That sort of sounds like you're going to be precluded.
Well, again, it seems to me the crux of my argument is that there was absolutely no reference to preclusion on appeal. That is, that there was plenty of notice or sufficient notice based on your prior cases that he was advised that this is what he had to do with the district court if he wanted to challenge his appeal.
Well, it seems like pretty easy to fix these forms and update them and avoid this problem.
Absolutely, no question, but I work with what I have.
Mr. Mears, your argument seems to would make or would have more logic to it if there was that gap between the plea and the sentencing, so the defendant may very well think that, well, if I'm only advised that I'm precluded from attacking the plea, that would only go up in time up until the time of sentencing. But in this case, didn't the defendant enter his written plea and then he waived time for sentencing, he waived all his defenses, he waived motion arrest of judgment? Wasn't it clear that he was just wanting to put this thing behind him?
He filled out the written guilty plea form at the pretrial. It was turned in to the judge and all handled on paper right then, or within 24 hours, I agree. But again, the rule talks about giving notice that you're going to be precluded from raising things on appeal. The word appeal never appears anywhere in that form, and that none of the cases, I don't believe, have ever found an advisory sufficient without some reference to preclusion or an effect in connection with appeal. If you want to read it out of the rule, you can do that.
What about his blanket waiver that I'm just gonna waive time for sentencing and let's just sentence me and get it over with. Does that change this case a little bit different from?
I wouldn't think so. I mean, the question is whether or not that written guilty form precludes him from being able to challenge a guilty plea directly on appeal, having been an adequate advisory under the rule. So let me talk about Carney, because Carney's a fun case. I mean, I guess as much as things are fun cases, but that what I really like about Carney is how it sort of fits in with the two other driver's license cases that were decided about that time, Dressler and the Hill case, where those cases, when contrasted with each other, make very clear that the loss of driver's license in connection with the possession of a controlled substance charge, conviction, I guess, is very different than the loss of license in connection with an OWI. And that I guess I preface that by saying this does get you into the world of collateral consequences. It gets you into the world of to what extent has that law changed after the Padilla case. It gets you to the question of to what extent is Carney still good law after it had dissent, and that several years later, Justice...
Don't we maybe not need to get into all of that if we just apply the principle that the taking away the driver's license from someone who's not convicted of a driving-related offense is punitive?
Absolutely. I agree. That is that, and to some extent, I didn't specifically say that Carney needed to be overruled, even though I think Carney isn't good law anymore. That is that Carney was an awful case. I mean, that this guy pleads guilty to first offense OWI in writing and then gets hammered with a 6-year loss of driver's license not having been told. And that the Supreme Court said over the dissent of 2 judges that this was because it wasn't punitive. Well, we know from those other cases that this particular loss of license for a PCS is punitive, so Carney doesn't apply. So I agree with you that this court can and should find that this loss of driver's license is a direct consequence, cannot be thought of as collateral. You go down that route.
How about the money? That's, you know, more and more there's surcharges and collection of various, and you have to be careful of nomenclature, I guess, fees, fines, restitution, et cetera. And of course we have that here. You know, it seems the purpose might be just to raise some money. How does this fit into the scheme of collateral consequence and punishment and so forth?
Well, a fine, everyone agrees, is a direct consequence. There's never any dispute about that.
Well, how about a charge, a surcharge?
Well, I mean,
For court purposes, for purposes of training law enforcement and victims restitution, I don't know, there's a laundry list there.
well, and to some extent, the percentage impact of that gets greater as you get lower in the scale of offenses. So that simple misdemeanors, you go in and you plead guilty to some simple...
But isn't the question, and you know, correct me if the framework is wrong, I know you will, but isn't the question, can those surcharges and restitution be characterized as punishment?
I think the surcharge is, it's just saying that a fine, which is regarded as punishment, is bigger than what you were told.
But, I mean, here's a potential problem I have there, Mr. Mears, and that is that in this case, he was advised of the maximum fine, the minimum fine. Now, even with the surcharges, it was still less than the maximum, right?
I don't think so. Well, it was less than the maximum, but I don't think necessarily for marijuana. Or that I guess it's the minimum that's the problem. That is, that he's advised as far as what the minimum fine is, and that's what he's getting. But that by the time you add 35%, it's a good deal bigger than what
I see
he had
what you're
been told
saying,
about.
yeah.
You know, you got several, I mean, I pointed out originally several problems with what I regarded as loosely penal consequences of this plea, that ranging, including the problem with the fine and the fact that he wasn't actually, this old form doesn't even say there's a minimum 2 days in jail for a PCS.
Oh, but on that one, it's a little hard for me to follow your reasoning because he knew the plea bargain was 2 days in jail.
And what I was.
And that's exactly what he got.
What I
right?
was going to get to is it seems to me that of those things, I would rank order them as the least strong would be the 2 days. A little bit stronger is the fact he was told about the minimum fine, but it was really a good deal more than that. And then there's the driver's license where he wasn't told at all, and this was a direct, punitive sanction imposed by the court. And it seems to me that there are two ways that you get to this being a problem. One is you conclude that he can challenge the guilty plea directly on appeal. And then secondly, that there was ineffective assistance of counsel, which gets you back to potentially the Padilla problem. And that's why I say I think that Carney is really not good law, but you don't have to go to Carney, recognizing that there was, in fact, a punitive driver's license sanction imposed in this case without him being told. And my 15 minutes are up. It's a tiny case. It's always interesting to have, or one can think of it as a tiny case, and that out of tiny cases can come some important principles. And appreciate your time.
Mr. Mears, thank you as well. Ms. Chambers.
May it please the court. The court has said repeatedly that substantial compliance is all that's required for Rule 2.82. Here we have substantial compliance. The defendant filed a written guilty plea that advised him that he had the right to file a motion in arrested judgment. That's what he had to do to challenge his plea, that he had to file that no later than 5 days before sentencing.
I'm going to ask you a question, because I can't ask Justice Appel a question, but I didn't see that preclude language anywhere in the written paperwork. Is it there? Can you help me find it?
Let's see. There are 3 spots.
Give me the strongest language you're relying on.
The strongest language is that in page 9 of the appendix, page 3 of the written guilty plea, it says, I hereby know, understand, and waive my right to appear in person, and I waive my right to file a motion in arrested judgment if sentencing is scheduled sooner than 5 days. And then there's also the language on page 5 of the written guilty plea, page 11 of the appendix, where the attorney states that he's carefully explained to the defendant the procedural steps for a motion in arrested judgment, the definition and grounds thereof, and the time within which such motion.
Generally don't rely on those attorney recitals to show compliance with 2.8, right?
We don't, but what's different about this case, though, than most cases, is the defendant also waived his presence. So what I suspect that the reason that's there is that probably at some point the parties looked at that written guilty plea and said, hey, it doesn't say anything, it doesn't say specifically that language about you'll be precluded from raising it on appeal. And so because the defendant wasn't there and they couldn't directly tell him that, counsel just made a statement that I explained that to my client.
And in connection with that, my problem is I couldn't find the preclude language.
I didn't find it either.
And on top of that, in the order signed by the judge told him he had an absolute right to appeal within 30 days. I mean, so when you put that in the preclude language, that bothers me even more. I mean, without the preclude language. Because the judge did not put in his order that, normally you put in the order of guilty that you have the arrested judgment language, But that doesn't appear in the order, but it affirmatively says he has the right to appeal within 30 days. And that's required by rule, I know, but that even bothers me more about what he was told and what he wasn't told.
There's a little bit of a conflict between what the court's required to say, if you don't do this, you can't appeal, and then they're also required to advise that they can appeal. But the language in the order about you have the right to appeal happened after the guilty plea. So that wouldn't have influenced the defendant in his decision and to file the written guilty plea. It might have.
Can he have 45 days after this guilty plea to appeal under the arrested judgment thing?
He would have if he hadn't waived time.
Right, and
Yeah, but the rules require, and your case law requires, substantial compliance. And it may be that what is substantial compliance will vary a bit depending on what the factual situation is. So in cases like this, where the defendant is represented by counsel, and where he waives his presence and he waives time, it's clear that what the defendant is trying to do is just get this over with. And I would note that
I'm not sure that that's probably true. I mean, most defendants want to get it over with. That was my experience when I represented them as well. But, the crux of the matter is, was this defendant really aware that he was going to lose his driver's license?
his counsel, we don't know. We don't know. And
Well, and then, under Rule 2.8, it's a responsibility of the court to establish that the defendant knows of the consequences, right?
it is. But in situations like this, where the defendant isn't there, it wouldn't have mattered if the court had advised it. The court could have said it to the empty courtroom.
And isn't it the state's, assuming, isn't it the state's burden to show compliance with 2.8?
It is. Frankly, in situations like this, where the defendant is represented by counsel, and where at least the written guilty plea says you have a right to file a motion to arrest judgment, and here's the time frame, it seems to me that the most efficient and probably just way to handle it is to say, if you want to challenge your guilty plea, go right to post-conviction. Don't waste your time and money coming up on direct appeal where we're going to have to decide if this is enough, because if it's not, then if it is enough, then you're still going to have to go back and do post-conviction, defendant.
What do you make of the Marin case? It seems to me what Marin, as I read it, establishes kind of two avenues, if you will, of challenging a guilty plea. One is the post-conviction relief, but Marin seems to me to say that if the 2.8 inquiry is not satisfied, then you can handle that on direct appeal, and it's the state's burden to show compliance, and if there's not compliance, it gets remanded.
The rule,
Am I missing it?
it does say that, and the rule requires that you both advise of the right to file a motion to arrest judgment, and you specifically say if you don't file it, you can't appeal it, which has never really made a lot of sense to me.
But our one case, what is it, you help me with it, I'm going to mispronounce it, the Zager case.
Oh, Zager,
basically requires that second prong, if you will, does it not?
It does, though it seems like overkill to me when we're looking at a substantial compliance standard, because we say you have to do it by this date, and I think for most non-lawyers that would mean if you don't do it by that date, that's the end of it. But then we also frequently require them to say, and also, you also can't do it on appeal. So,
normally the defendant would be there and the court would say this out loud,
Right.
and we'd have a record of it. Don't you think it's more important for the court to put it in their written ruling?
it's too late then, though.
In their written documents?
I would
the plea documents that the court's going to accept, so the court knows this happens. The problem is you're saying, well, he waived everything he wanted to get out of there, but we don't know whether, he knew there was a chance to lose his license. We don't know whether or not he knew an arrested judgment. And going back to what Justice Appel says, what's so hard about a court including it in their form and requiring it?
I would like to see that in their forms, and I would like the courts to keep their forms updated. That's just not anything I
But
can
if we
control.
keep holding substantial compliance and it's good enough for government work and things like that, it's never going to get done.
I think it's in this court's power to make that be done. It's not in mine. But the bottom line here is, I caution us to not elevate form over function. We have a defendant here who just wanted to get this over with. According to the letter he wrote to the court, he's already out of state. He's already living in California. So he authorized his attorney to show up and enter his guilty plea. Yeah, while I think that guilty plea is minimally adequate, it certainly isn't an example of great drafting. It certainly should be updated.
Can we talk about Carney a bit?
Yeah.
You heard the colloquy about Carney, and Carney does use language, just to put it on focus. It says that the purpose of the suspension of the driver's license was to protect the public by providing that drivers who have demonstrated a pattern of driving while intoxicated are barred. Well, I mean, here we don't kind of have the pattern of driving while under the influence. Does that make a difference, or what's your view of that?
I acknowledge that the court has, in Dressler and in Hills, has found that the driver's license revocation for drug offenses is punitive. If the defendant were allowed to attack this directly, those are very bad cases for me. We have Carney, which said in the OWI context, it's not punitive, it's remedial and protective of society and not punitive. I recognize that Dressler and Hills are closer to on point than Carney. And while I think there are some reasons why the drug revocation is protective and not punitive, it does protect the motoring public, and there is a connection, if maybe less direct, but there is a connection between intoxication by whatever substance and driving. It is admittedly less direct in the case of drug convictions than in OWI convictions.
Would we have to overturn Hills and Dressler to get to where you want to go?
I don't think you'd have to overturn them because neither one of those addressed it directly in the context of collateral consequences. They addressed it in the ex post facto and double jeopardy context. So you wouldn't have to overrule them. I think it would be useful to distinguish them.
About the financial questions then, in terms of collateral consequence?
The financial in terms of the surcharge?
Surcharges and restitution.
I think those are pretty clearly non-punitive. It has to, in order for the court to be required to advise, it has to be both a direct and nearly automatic consequence, and it also has to be punishment. And those have been found repeatedly to be not the kind of thing that is punitive. It's intended to raise money for victim services and court services and education programs. It's not intended to punish the defendant.
Well, so does that mean that if we had, like in the financial industry, a $100,000 fine, as long as we said it's dedicated to court improvement, that would take it out of the punitive?
I imagine that at some point the credibility of that claim would be suspect. At some point, I imagine that a surcharge would be so high that the court would say, I just don't believe you that that's not intended to be punishment. I just don't believe you that that's intended only for remedial purposes. And that would be an issue for the court. But here, it's been gradually raised over the years and it really is being channeled to victim services and appropriate non-punitive sources. And so here, at this point, at this level, I don't think that is an issue. So I want to just say, I didn't see a lot of receptive looks, but I want to go back to the post-conviction attack, because it really does make sense to me to both preserve judicial and lawyer resources, at the same time protecting the rights of defendants, to deal with these guilty pleas in the context of post-conviction. Almost always, attorneys are going to have advised their clients about all of these things, and here, we have really good reason to believe that because the attorney filed something with the court saying he had covered all these topics. And it doesn't make a lot of sense to me in terms of the balance of benefit and cost to say we're just going to vacate these guilty pleas. In this case, for example, this defendant doesn't even live in the state anymore. So we're not even going to go back for a trial. We're going to go back for issuance of a warrant. If and when he comes back in the state and we happen to come across him, he'll be arrested, and then we'll probably start over, and he'll probably plead guilty again. The minutes of testimony show that an officer walked into a bar in Iowa City, smelled marijuana, walked back, saw a defendant,
So does
asked him if he's...
expediency just overrule these rules and constitutional rights and all this stuff? I mean, you're probably right. I mean, it's a small case in the scheme of things, but, you know, the rules are there for a purpose, and the constitutional rights are there for a purpose, and it would be so easy to do it in this case. I mean, it wasn't like it couldn't be done. It was a judge who may have been sloppy or remiss and not looking for what he needed to do it. I mean, we're not talking about, you know, an error that nobody should have not known about.
I agree. It was sloppy, and they should have covered it, and they should keep their forms up to date. I don't dispute that. I'd be, you know, I don't enjoy working on cases where they could have taken care of it in 30 seconds. But the bottom line is, we wouldn't be saying close enough, and we wouldn't be ignoring constitutional rights. We're just saying, go to post-conviction. If you knew about these rights, then we would be vacating for
Case
no
and
good
he
reason.
pled, and the person pled guilty, would you have the same attitude? Well, he's just gonna do this,
Yeah,
and
I
this,
actually
and-
would. Yeah, I mean, if they actually knew what they were doing when they're entering their guilty pleas, then there's no good reason to set those guilty pleas aside. We're simply starting over.
If this had played out in a PCR and his trial counsel had said, no, when I certified, I explained this stuff. In fact, I remember talking to him, and I said, you're going to lose your license for 6 months. You still want to go forward? And he assured me, yes, I'll do that. So then we'd have we'd be in a different position. We'd be better informed.
We'd be better informed. And we,
But more likely,
Depends
what
when the defendant says, he didn't tell me that.
more likely, counsel
That is an
doesn't
issue of
remember
proof.
because this is a possession case of one of 300 cases that they dealt with. Counsel doesn't remember, and the client comes in and says, well, if I would have known driver's license, I would have never pled. And, you know, it's kind of self-serving. And so the PCR vehicle may not be ideal.
Kind of on the practical side, I mean, it's sort of either put the burden on the state to, like you say, somehow bring him back, get him back, and bring him to trial, or you put the burden on this fellow who's now living in California or whatever to try and set aside his conviction. Someone's going to have the burden. So I'm not sure the practical argument weighs too heavily. I mean, don't we just have to kind of see where the cases lead us?
kind of, but I would point out again that this is not a case where he was uncounseled or where there was no mention of the motion and arrest of judgment. This is just one of those cases where he clearly knew at least part of it, and the only question is how deadly clear it was that he also wouldn't be able to challenge it on appeal.
But is that argument ignoring the rule itself, though? Because the rule says the court shall inform the defendant.
It doesn't, and that whole rule is full of things that the court is supposed to inform, and on all of them, this court has said substantial compliance is enough, and specifically for serious misdemeanors, it said a written guilty plea serves that function. And the court can't inform the defendant when he's waived presence, of course. So
Well, this is more than just potential error of trial counsel. It's the court is required to perform the function.
it is, and were the defendant present, certainly the court would have been required to say those things. The defendant wasn't there, so the trial court judge could have said those things out loud, but again, he would have been speaking to an empty courtroom. I know that what the rule says, and the court has said substantial compliance, and frankly, you'll just have to decide whether this is substantial enough for you. I know it's not the strongest case, but where this defendant has waived presence and waived his right to file a motion and arrest of judgment, I think that should be enough. Thank you. I think I'm over.
Ms. Chambers, thank you as well. Rebuttal?
Just a couple things. With regard to the question of substantial compliance with the rule regarding the motion and arrest of judgment, that the Marin case pointed out that the court, I'm sorry, I lost my place, that we need not decide if Barnes can be extended as urged by the state. Rule 2.82D clearly imposes two requirements, and that I suggest or support that substantial compliance has to be with regard to both. It's not substantial compliance if you just comply with the first.
Why don't you respond to the comment, the simplest approach or the easiest approach or the most expedient approach is just to do a confirm the conviction and the plea and the conviction, and that you ought to just proceed to post-conviction.
You know, I wrote down here when that discussion was going on, one really important distinction between a direct appeal challenge and the post-conviction is whether you've served the sentence. And that Mr. Fisher hasn't served the 2 days in jail. And that there's no stay or there's no delay in serving the sentence if you defer something to a post-conviction, because by that point you will have actually served the sentence. On the question of whether or not this is a direct consequence, that there was language in the cases before Carney that talked about what was a direct consequence. And that language talked about it was immediate and that it was direct and that I'm not sure what it was, but what the other one was. But what was important was that I think, Justice Appel, you wrote in one of those deferred judgment cases about the proliferation of collateral consequences. And there's just so many things that can happen if if you're a student and you plead guilty to PCS, you are ineligible for student loans or something like that. But that here, the loss of driver's license is imposed by the court in the sentencing order, and it happens right then. Actually, it may be delayed for the DOT processing the paperwork. And that before Carney, you would have thought that a 6-year loss of license in connection with an OWI first sentencing would be a direct consequence. It wasn't, for the very rare fact that that was deemed non-punitive. That we already have the Supreme Court saying this particular loss of license is punitive because of the lack of connection, that it absolutely should be clear that this is a direct consequence, and that as a direct consequence there is an obligation of the court to make sure that there is information about that. I do believe that a court in a lesser offense, like a misdemeanor, is allowed to rely on the recitations that appear in a written guilty plea. I don't think you have to have a colloquy every time a misdemeanor pleads guilty on paper, but that you have the written plea that has to substitute for the information that otherwise would happen in the colloquy. And if the colloquy has to cover all the direct consequences, we know that from the rules of procedure, that under those circumstances, the 6-month loss of license is a direct consequence that has to appear someplace. I think that Mr. Fisher can raise this on direct appeal. I think if he can raise it on direct appeal without having to use ineffective counsel, you don't have to go down the road of deciding whether there is prejudice, that the guilty plea falls and the matter should be sent back to allow him to plead anew. Appreciate everybody's time, I urge that the court set aside this conviction and send a note to the district associate judge to get rid of these forms. Thank you.
Thank you, Mr. Mears. State versus Fisher is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.